The moment you pull that trigger, your entire life splits into two timelines. In one, you walk away believing you did what you had to do. In the other, you sit in a cold interrogation room while detectives pick apart every second of your decision. There is no rewind button. There is no, "I didn't mean it like that." There is only what the law says and what a jury believes. So let me ask you something straight up. If someone broke into your home at 2 a.m., would you know with absolute confidence whether you could legally shoot them in self-defense where you live? I want you to think about that seriously, and I want you to answer it in the comments. Tell me what state you're in and what you believe the law allows. Because what most people think they know about self-defense and stand your ground laws is often incomplete, outdated, or just plain wrong. And if you stay with me, I'm going to walk you through how this really works in the United States, how prosecutors analyze these cases, how police approach them, and why one tiny mistake in judgment can turn a self-defense situation into a murder charge. Let's start with the uncomfortable truth. Self-defense law in America is not about what you felt. It is about what a reasonable person in your position would have believed at that exact moment. That single concept decides whether you go home or go to prison. Most people simplify it down to something like, if I feel threatened, I can shoot. That is not how it works. The law revolves around imminent threat, not future threat, not past threat, not, he looked dangerous. Imminent means immediate and unavoidable. The danger must be happening right now or about to happen right now. Imagine someone screaming at you from across a parking lot saying they're going to kill you. They're unarmed. They're 40 feet away. You pull a gun and fire. That is almost certainly not going to qualify as lawful self-defense. Words alone, even terrifying words, are rarely enough. Now let's move into what actually matters: proportionality. The force you use must match the threat you face. Deadly force is only justified when you reasonably believe you are facing imminent death or serious bodily harm. Not a shove, not a punch, not property damage. Serious bodily harm means something that could permanently disfigure you, disable you, or kill you. This is where things get messy, because in real life, situations unfold in seconds. You don't get a courtroom pause button to analyze whether the other person's hand movement was reaching for a wallet or a weapon. But here's what you need to understand. After the fact, every frame of your decision will be examined in slow motion. Detectives will measure distances. They will look at security footage. They will examine your prior statements. They will pull your social media. They will evaluate whether you escalated the situation. That word escalated is critical. If you provoke a confrontation, you may lose the right to claim self-defense. If you start the fight, or aggressively pursue someone, or continue a conflict when you could safely disengage, your legal footing becomes extremely fragile. Now let's talk about duty to retreat versus stand your ground. This is where most confusion happens. Traditionally, many states required a person to retreat, if safely possible, before using deadly force. The idea was simple. If you can avoid killing someone by walking away, the law prefers that you walk away. That's called the duty to retreat. But then came the wave of stand-your-ground laws. The most famous example is Florida's statute, enacted in 2005, which removed the duty to retreat in places you have a lawful right to be. That means if you're legally present somewhere and not committing a crime, you do not have to retreat before using deadly force if you reasonably believe it is necessary to prevent death or serious bodily harm. Other states followed with their own versions. Some adopted broad stand-your-ground statutes. Others kept a limited duty to retreat. Some states recognize stand-your-ground through court decisions rather than statutes. The result? A patchwork of laws across the country. And here's the part travelers constantly overlook. Your concealed carry permit, your understanding of your home state's laws, your assumptions about Castle Doctrine do not automatically transfer perfectly when you cross state lines. Castle Doctrine is another concept people throw around casually. It generally means you have no duty to retreat inside your home. The logic is that your home is your sanctuary. But even that has limits. If the intruder is fleeing or no longer poses an imminent threat, shooting them in the back as they run out the door will almost certainly not qualify as lawful self-defense. I've seen people confidently say, "If they're in my house, it's open season." That mindset is dangerous. Prosecutors don't see it that way. Jurors don't see it that way. And the law absolutely does not see it that way. Let's break down what police look for at a shooting scene. When officers arrive, they don't automatically label someone as the victim or the hero. They secure the scene. They separate witnesses. They collect weapons. They note emotional states. They look for inconsistencies. They're trained to treat every shooting as potentially criminal until the evidence shows otherwise. If you claim self-defense, your statement matters. What you say in the first minutes can shape the entire investigation. If you ramble, speculate, exaggerate, or contradict physical evidence, that becomes ammunition for the prosecution later. And yes, even legally justified shooters are often handcuffed, transported, and questioned. Now let's go deeper into what reasonable belief really means. It doesn't mean you were actually in danger. It means a reasonable person in your position would have believed they were in danger. That's an objective standard layered over your subjective experience. For example, if someone reaches suddenly into their waistband during a heated confrontation and you genuinely believe they're drawing a gun, that may support a self-defense claim, even if they turn out to be unarmed. But if witnesses testify that the person's hands were clearly visible and empty, your belief starts to look unreasonable. This is why situational awareness and de-escalation matter so much. If you willingly step into volatile environments, argue aggressively, or brandish a weapon early in a conflict, you are stacking legal risk against yourself. There's another layer that doesn't get enough attention: immunity hearings. In some stand-your-ground states, defendants can request a pre-trial immunity hearing. If they convince a judge that the use of force was lawful under the statute, they can avoid a full criminal trial. But that process is not automatic, and it's not easy. The burden often falls on the defendant to prove entitlement to immunity by a preponderance of the evidence. And if immunity is denied, the case proceeds to trial, where the standard becomes beyond a reasonable doubt. Let me be blunt. Even a good shoot can cost you hundreds of thousands of dollars in legal fees. It can cost you your job. It can fracture your family. It can place you under a microscope for months or years. Being legally justified does not mean being free from consequences. Now let's talk about scenarios travelers misunderstand. Road rage incidents are a classic example. Someone cuts you off. You exchange words. The other driver gets out and approaches your car. Your heart is pounding. Can you shoot? It depends. Are they armed? Are they trying to force entry into your vehicle? Can you drive away safely? If escape is possible, and you choose instead to stand your ground aggressively, your claim weakens significantly. In some jurisdictions, remaining inside a locked vehicle may strengthen your position if the attacker attempts forced entry. But stepping out of your car to confront someone, that can shift you from defender to aggressor in the eyes of the law. Public spaces add complexity. In crowded areas like airports, shopping centers, or events, stray rounds become a factor. Prosecutors will ask whether your decision endangered bystanders. Even if you were facing a threat, reckless disregard for innocent people can trigger additional charges. And here's something most gun owners don't think about: disparity of force. A physically smaller or elderly person facing a much larger attacker may reasonably perceive a threat of serious bodily harm even if the attacker is unarmed. Multiple attackers against one individual can justify deadly force where a single unarmed attacker might not. Self-defense law is highly fact-specific. Tiny details matter: lighting conditions, distance, prior history between the parties, whether there were opportunities to disengage, whether warnings were given, whether the defender continued firing after the threat stopped. Yes, that matters too. Once the threat is neutralized, the legal justification ends. Continuing to shoot after the attacker is down or fleeing can destroy an otherwise valid self-defense claim. I also need to address something uncomfortable: Your own words before the incident can haunt you. Social media posts bragging about wanting to smoke a burglar or finally use my gun can be introduced in court to paint you as someone eager for confrontation. Prosecutors build narratives. They look for motive. They look for mindset. Now think about this from a traveler's perspective. You're in a state with stand-your-ground laws. You're carrying legally. You intervene in a bar fight to help someone. Suddenly, you're part of the chaos. The aggressor shifts focus to you. You fire. Were you legally justified? Possibly. But did you voluntarily insert yourself into a volatile situation? That will be examined carefully. There's also civil liability. Even if you are cleared criminally, the family of the person you shot can file a wrongful death lawsuit. The burden of proof in civil court is lower than in criminal court. That means you can win criminally and still lose financially in civil court. I want to circle back to something critical. Mindset. Self-defense law rewards restraint, not bravado. It protects people who genuinely had no safe alternative. It does not protect people who were looking for a fight. And I'll tell you this from years of studying these cases. The individuals who fare best legally are often the ones who avoided dozens of confrontations before the one they couldn't avoid. They park in well-lit areas. They disengage from verbal insults. They don't chase ego battles. They understand that the best gunfight is the one that never happens. Stand your ground does not mean stand and fight. It means you are not legally obligated to retreat if you are somewhere you have a lawful right to be and face an imminent threat of serious harm. But just because you can stand your ground doesn't always mean you should. Tactical retreat can save your life and protect your freedom. And here's the final piece I want you thinking about. Every self-defense case becomes a story told to 12 strangers in a courtroom. Those jurors will evaluate whether your actions were reasonable. They will look at you. They will listen to your voice. They will see the footage. They will decide whether you acted out of necessity or anger. So before you ever find yourself in that split-second decision, ask yourself something harder than the comment question I gave you earlier. Are you prepared not just to survive the encounter, but to survive the legal aftermath? Because knowing when you can legally shoot in self-defense isn't about memorizing slogans. It's about understanding principles, respecting the gravity of deadly force, and realizing that the law is both shield and sword. It can protect you, but if you misunderstand it, it can turn on you fast. Think about your state. Think about your assumptions, and if you haven't actually read the statute where you live, maybe tonight is the night you do.